Hi, everybody. I'm going over the Colorado Supreme Court says Office of Attorney Regulation Counsel, complaints and disciplines. But they only have where you can file a complaint. Now look, complaints and discipline. But you need the rules of professional conduct. And it's not here. The complaints and discipline, it says file a complaint. See, there's a lot of stuff you can find here. Oh, here it is. Practice of law. Let's see what the rules come up with. Okay, this isn't what we're looking for, okay? What it really doesn't tell you where the rules of professional conduct are. Rules governing administration, that's not, you're looking for the rules of professional conduct. And I couldn't find it in their sites. Okay, so look what I had to do. Okay, we're going to open up in a new tab. See, I'm always, I've been checking every state. Watch. Okay, there are your rules. Okay, for the people that had cases already, what they think is resolved, it ain't over till we say it's over. Okay, and I'm talking about we the people. All right, remember how in my video I spoke of a synopsis? Well, that's the preamble, and it'll mention terminology, client-lawyer relationship. So if you're in a court of law, and when you walk in the room, especially for anybody that uses the public defender, okay, now it used to be in the Illinois rules of professional conduct, but for some reason every state took it out, and it's called ineffective assistance of counsel. So if you walk into a room and into that very dark place, the court, and you walk in there and you don't know, I can guarantee you don't know what's going on. So you got a public defender, and even if you're using a lawyer in whatever court, things aren't going your way, you want to cite them for ineffective assistance of counsel. And say, you'll look up competence, but you don't even have to explain it to them because these people know the rules. So you tell him, Your Honor, he's ineffective assistance of counsel. Let's see, where are these? Misconduct. Because we're gonna. So when you cite them for, it's down here, 8. Ineffective assistance of counsel. He says, "What do you mean?" And then you'll print these rules out and take them with you. Okay. Misconduct. Okay. It is a professional misconduct for a lawyer to violate or attempt to violate the rules of professional conduct. Okay. So he's going to say, what rule is he not applying? So you're going to go to competence. He may be a competent attorney, but he's acting in an incompetent manner by not displaying diligence, a lack of communication, confidential of information, because anything you tell him, he tells the judge and the opposing party. Okay, and then you want to go cite him as an advisor, violation, did not comply. Okay, and then you'll cite him for violation of Rule 3.1, meritorious claims and contentions. Because if you read the preamble says that they have to tell you about this. It says you need reasonable knowledge to make an informed decision and or informed consent. So if you don't know these rules exist, anything can be construed as merit or a violation as meritorious claims and contentions. Expediting litigation. Litigation, it'll say right here, expedited. As amended, a lawyer shall make reasonable efforts to expedite litigation consistent with the interest of a client. So if your lawyer comes to court and he says, well, the opposing party didn't give me this or give me that, he should have had that from the very beginning, before they ever appeared in court. Okay? So you want to cite them for that. Okay, expediting litigation. Candor towards a tribunal. You can cite them for that. A lawyer shall not knowingly make false statements or material fact. You get the idea. Fairness to the opposing party. You want to cite, when you cite this, you're going to be citing the opposing party. Fairness to the opposing party and counsel. You are the opposing party and counsel is your lawyer or attorney. A lawyer shall not unlawfully obstruct another party's access to information. So when you cite the opposing party, you're also going to cite him for a lack of diligence, okay? A lack of diligence, a lack of communication between you and your counselor. So it's gonna. You should print this out, all the rules, and then just start citing them one by one. Candor toward fairness to the opposing party, counsel, impartiality, and decorum of the tribunal. Now, see, when you cite this rule, that takes down the judge, your lawyer, and the opposing party. A lawyer shall not seek to influence a judge nor juror, prospective juror, other official means by. Okay, so you're just going to want to go through this, but you can use it. You got to read it, okay? Fairness, impartiality, trial, publicity. You're going to cite them for that. A lawyer was participating or has participating in the investigation, litigation, or matter shall not make extrajudicial statement the lawyer knows or reasonably should know was disseminated by the means of public communication and will have substantial likelihood of material of prejudicing the objective adjudicative proceeding in the matter. Okay, so this happens a lot. You'll see CPD, state's attorney. You see lawyers go out there and talk about a lot of this stuff. Okay, in a criminal case, in addition to some paragraphs, the identity, residence, occupation, and family status of the accused has been apprehended. See, now you can use that against your lawyer because the state's attorney will bring up your history to the judge. Now that's prejudicing the judicial process. Okay. So if your lawyer says, hey, I want you to take a judge or a bench trial because this judge is good, that's, up here. Well, let me just go back down. But you're going to have to print this out and go over it. Okay, dealing with an unrepresented person, lawyers often violate that. Rights of third persons, threatening prosecution. We don't have that in Illinois. A lawyer shall not threaten criminal, administrative, or disciplinary charges to obtain advantage in a civil matter. That's quite often violated. Okay, so I'm going to do my best to put this all together. Okay, I'm just showing you what you can say. You can use these rules against them in court. Print it out. Communication concerning a lawyer's service, they often violate that. Solicitation of clients, often violated. But the one I'm doing is basically going to be a general for the rules I know that they break. Depending on your case in court, you may want to take out a rule that they didn't violate and add another rule that they did violate. But this one, they always violate misconduct. They violate any of those rules, that's misconduct. And since the opposing party and the judge aren't reporting that, that's a violation of that rule. So I'm going to throw that in. I'm going to mix up the words. If you watched my video, you can see how I went to court and went full Magna Carta on demanded rule of the law. Because before you can proceed in the court, you got to know this. They're supposed to tell you. Let's go to the preamble. Okay. A lawyer is a member of the legal profession, is a representative of clients, an officer of the legal system, and a public citizen having special responsibility for the quality of justice. As a representative of clients, a lawyer performs various functions. As an advisor, a lawyer provides a client with informed understanding of the client's legal rights and obligations and explains their practical implications. Now, if you don't know this, they're violating your right to due process. Okay, so I'm hoping you get the understanding that all this is an explanation of due process. Okay, so if you don't know, it says right there, provides client with informed understanding of the client's legal rights and obligations and explains their practical implications. As an advocate, a lawyer zealously asserts the client's position under the rules of the advisory system, meaning the court. As a negotiator, a lawyer seeks a result advantageous to the client but consistent with requirements of honest dealings with others. As an evaluator, a lawyer acts by examining a client's legal affairs and reporting about them to the client or to others. In addition to these, that's three. In addition, these representational functions, a lawyer may serve as a third-party neutral. Some of these rules apply directly to a lawyer who have served as third-party neutrals. In addition, these rules that apply to lawyers who are not active in the practice of law, meaning a judge, or to practicing lawyers, even when they are acting in a non-professional capacity. For example, a lawyer who commits fraud, which you'll want to use that term when you go to court, because what they're doing by not telling you all this is perpetrating a fraud. And any continuance is professional procrastination. So if a lawyer says, well, Your Honor, I need a continuance because the opposing party, whether it be the state's attorney or in civil court, just the opposing party, and discovery isn't complete, that's a violation of your right due process. Okay, all professional functions, a lawyer should be competent, prompt, and diligent. Okay, competent, meaning competence would be telling you this if he acted in a competent manner. Prompt, okay, you know what prompt means, quick, fast, in a hurry. Diligent means getting everything done quick, fast, in a hurry. So they're playing with words right here, but just read it and you'll understand. If I can understand it, you can understand it. A lawyer shall maintain communication. They don't do that with a client concerning the representation. A lawyer should keep in confidence information relating to representation of a client except so far as disclosure is required or permitted by the rules of professional conduct or other law. A lawyer's conduct should conform to the requirements of law, both in professional service to the client and the lawyer's business and personal affairs. Personal affairs, meaning if they're out there talking on the camera, what must they do? Okay, this here tells you. A lawyer should use the law's procedure only for legitimate purposes and try not to harass, intimidate others. Like those lawyers are doing filing in, Pennsylvania. I don't watch the mainstream media, and I don't like going on the net because every time I turn around, somebody's doing something they should. Those lawyers that are trying to uphold the election, violating the rule meritorious claims to contention. See, when they come to court, they have to have something to substantiate their accusations. And if they're just going on by something they've seen on the internet, that's batshit crazy. I'm not into politics, people. I don't like politicians because the lawyers are the ones that help politicians do what they do and they shouldn't do. And this will explain it to you. A lawyer should use the law's procedures only for legitimate purposes and not to harass or intimidate others. A lawyer should demonstrate respect for the legal system and those who serve it, including judges, other lawyers, and public officials. See, now them going out there talking politics, lawyers, that's not supposed to happen. While it's a lawyer's duty when necessary to challenge the rectitude of official action, it's also a lawyer's duty to uphold the legal process. As a citizen, as a public citizen, a lawyer should seek improvement of law. Now, improvement of law is what I've been demanding. Magna Carta. People, remember that term, Magna Carta. That's old school for rule of law. Okay, as a public citizen, a lawyer should seek improvement of the law, access to the legal system, the administration of justice, and the quality of service rendered by the legal profession. As a member of the learned profession, people, remember that when you go to court, you don't have to talk like a lawyer or understand any demand. They put it in layman terms, okay, because you are not a member of the learned profession. A lawyer should cultivate knowledge of law beyond its use for clients, employ that knowledge in reform of the law, and work to strengthen legal education. In addition, a lawyer should further the public's understanding. See, they don't do that. A lawyer should further the public's understanding of the confidence in rule of law and the justice system, because legal institutions in a constitutional democracy depend on popular participation and support to maintain their authority. A lawyer should be mindful of deficiencies in the administration of justice that the poor and sometimes persons who are not poor cannot afford adequate legal assistance. Therefore, all lawyers should devote professional time and resources and use civic influence to ensure equal access to our system of justice for all, and those because of economic and social barriers cannot afford to secure adequate legal counsel. A lawyer should aid in the legal profession in pursuing these objectives and should help the bar regulate itself in the public interest. What they mean by regulating itself is if there's misconduct, reported. Reporting misconduct is mandatory in a court of law. So if you learn this stuff, you don't even have to remember it. And you can't take a phone or any electronic equipment, so print this out, okay? And highlight every issue that you think will help you in a court of law. So when you step before a judge, you're going to go over this with them. And they will vacate the room. They will. They'll call for a sidebar, and the judge and the lawyers will leave, and they won't include you in that. If you are the client, remember, they're calling your lawyer is assistance of counsel. Why are they calling your assistant in there and not you? That is forbidden. Okay, so don't let them keep you out of the loop. The whole thing is they're supposed to keep you in the loop. Instead of asking for reasonable knowledge, you want full knowledge. You want full disclosure. And in my complaint to the Illinois Supreme Court, I not only as demanded full disclosure for myself, but for the people. I said, not you betrayed my trust. And when I speak of me, I mean we, as in we, the people. So this is how we defend our constitutional right to due process if you walk in a court of law. Okay, what I'm going to do is some paperwork with people who, that already been through this and they think they have no avenue out. I'm going to do my best and get everything done as quick as possible and post it on my site, Legal Reform, for every state. And all you're going to have to do is critique it. I'm going to write up the necessaries for you to explain this, but I'm going to put it in a short form, a synopsis of this synopsis. And so you'll file that in court. And demand Magna Carta, rule of law, okay? This says rule of law. It's just that nobody's telling you this. That's why it's not happening, okay? Nobody's telling you what you're supposed to know. So to me, this is how you own and operate an attorney. Okay, this is the owner-operator's manual. People used to tell me I was lucky in court. I wasn't lucky. I took this with me, and I took out a yellow This was just I found this when it was just in books. Thank God for the internet. Now I can get to you, and I do. I do thank God on a daily basis. We communicate. So also, a lawyer can be sure that preserving client confidence ordinarily serves the public interest, okay? The public interest. We are the public. We the people. So also, a lawyer can be sure that preserving client confidence ordinarily serves the public interest because people are more likely to seek legal advice and thereby heed their legal obligations when they know their communications will be private, meaning he can't go tell the judge what you're talking about or the state's attorney. The only thing he's obligated to do is share what he has with the opposing party and the judge. And the opposing party has to share what they have. That's called discovery. And that has to be done before they walk in the court. The first time they walk in court, this should be done. But they'll tell you, we got a process, and that means they go back to the office and they tell their secretary and they send off a note to whoever, and then eventually makes it down to their mailroom, then gets through the mail service and eventually winds up at the opposing party's office. Then that's got to work its way up to the lawyer for them to give an answer. And this is taking too fucking long. Excuse my language. All they have to do is walk across the table and hand it to each other. And even before they come to court, they should visit each other and say, one or the other should, hey, here's my copy of everything we're using, list of witnesses, video footage, whatever it may be. Okay, that's discovery. Everything and anything that can be used in a court of law or that they want to. So, I mean, I don't see the big hassle about, all these dash cams from police, their body cams, why they take so much time. That there should be immediate disclosure. That's part of discovery. So it's required for them to disclose this to you. And when I say you, I mean we as the public. Public interest must be served. Okay, virtually all difficult ethical problems arise from conflict between a lawyer's responsibilities to clients, to the legal system, and to the lawyer's own interest in remaining an ethical person while earning a satisfactory living. A satisfactory living. Keep that in mind. They can't use it to get rich because with every continuance that's professional procrastination, that means they get a check for every continuance from you, from the state. Our taxes are being wasted because of professional procrastination. Rules of professional conduct often prescribe terms for resolving such conflicts within the framework of these rules. However, many difficult issues of professional discretion can arise. Such issues must be resolved through the exercise of sensitive professional and moral judgment guided by the basic principles underlying the rules. These principles include the lawyer's obligation zealously to protect and pursue a client's legitimate interest within the bounds of the law. Zealousness does not, under any circumstance, justify conduct that is unprofessional, discourteous, or uncivil towards any person involved in the legal profession. And that includes your politicians because they are involved in the legal profession. Okay, so remember that. They work for you. Every politician out there, from your on the local level, state level, state reps, congressmen, governors, the president, including cops. Okay, because this is where it starts with the police. The legal profession is largely self-governing, although other professions have also been granted powers of self-government. The legal profession is unique in the respect because of close relationship between the profession and the process of government and law enforcement. The connection is manifested in the fact that the ultimate authority over the legal profession is vested largely in the courts. Now, keep in mind, all this must be done in the public interest to maintain the public trust, which we'll mention in the scope. but I'm only going to go over the rules. The preamble. You'll have to go over the scope yourself. I want you to read this. Okay. So an independent legal profession is important in preserving government under law. For abuse of legal authority is more readily challenged by profession whose members are not dependent on government and right to practice. That means us, me, you, we the people. The legal profession's relative autonomy carries with it special responsibilities of self-government. The profession has a responsibility to ensure that its regulations are conceived in the public interest and not in furtherance of a patriarchal or self-interest concerns of the bar. That means any lawyer. And judges have to be lawyers. They just can't practice law while they're judging. So let me go over that again, okay? The profession has a responsibility to ensure that its regulations are conceived in the public interest and not furtherance of patriarchal or self-interest of the bar. Every lawyer is responsible for the observance of the rules of professional conduct. The lawyer should also aid in securing their observance by other lawyers. Neglect of these responsibilities compromises the independence of professionalism and the public interest in which it serves. Lawyers play a vital role in preservation of society. Fulfillment of this role requires an understanding by lawyers of their relationship to our legal system. The rules of professional conduct, when properly applied, serve to define that relationship. And the scope, let's see, how long is it? Oh, it's not too long. Okay, so let's go over that. Rules of professional conduct are rules of reason. They should be interpreted with reference to purposes of legal representation and law itself. Some of these rules are imperatives cast in the terms shall or shall not. These define proper conduct for the purpose of professional discipline. Others generally cast in the term may as permissive and define areas under the rules in which a lawyer has discretion to exercise professional judgment. No disciplinary action should be taken when lawyers choose not to act or acts within the bounds of such discretion. Rules define the nature of the relationship between the lawyers and others. The rules are thus partly obligatory and disciplinary and partly constructive and descriptive in that they define a lawyer's professional role. Many of the comments use the term should. Comments do not add obligations to the rules but provide guidance for practicing in compliance with the rules. Practicing in compliance with the rules. Did you hear me? 15. The rules presuppose a large legal context shaping the lawyer's role. The context includes court rules, statutes relating to matters of license, laws during specific obligations of lawyers, such as substantive procedural law in general. The comments are sometimes used to alert lawyers to their responsibilities under such other law. 16. Compliance with these rules, as with all in law, in an open society, depends primarily upon the understanding and voluntary compliance. Okay, well, I'm pretty sure you can get to the rest, okay, because there's something else I want to go over with you, okay? Okay, remember how I said reporting misconduct? Okay, reporting misconduct is necessary. It's a lawyer who knows that another lawyer has committed a violation of the rules of professional conduct or raised a substantial question as to the lawyer's honesty, trustworthiness, or fitness as a lawyer in other aspects shall inform appropriate professional authority, which is the Supreme Court of your state. A lawyer that knows that a judge has committed a violation of applicable rules of the judicial conduct that raises a substantial question as to the judge's fitness for office shall inform the appropriate authority, which is the Judicial Inquiry Board. Different states have different names for that. C, the rule does not require disclosure of information otherwise protected by Rule 1.6 or information granted by a lawyer or a judge while preserving as a member of a lawyer's peer assistance program. has been approved by the Colorado Supreme Court initially upon renewal of extended. Such information would be confidential and communicated subject to attorney-client privilege. Okay, in the comments, as they said, these are warnings to lawyers that you have to act in this manner. Okay, a report about misconduct is not required where it would involve violation of Rule 0.16. However, lawyers should encourage a client to consent to disclosure when prosecution will not substantially prejudice the client's interest. The lawyer were obligated to report every violation. Never mind that, because that part just telling you, well, lawyers can't use these rules against each other to have each other disbarred just to throw out the case. But see, you can. The duty to report professional misconduct. Oh, I already read that. But anyways, just go over this and you'll understand reporting professional misconduct. And misconduct easily says in the professional, it is professional misconduct for a lawyer to violate or attempt to violate these rules of professional conduct. Okay, so you can charge your lawyer or cite your lawyer for misconduct simply because he didn't tell you all this. They're supposed to tell you. I read the preamble. Okay, is it code? It should come up. There it goes. See, Google already knows. Okay, so you're gonna want to. I do this a lot. Try to talk to people. Okay, you want to read? You should really print this out and take it with you. Okay, because you're gonna want to use the rules of professional conduct. Are some big guns in the court of law, but these are even bigger. Your canons. A judge shall uphold and promote the independence, integrity, and impartiality of the judiciary, and shall avoid impropriety and the appearance of impropriety. A. Compliance with the law. A judge shall comply with the law, including the Code of Judicial Conduct. B. Conduct by a judge that violates a criminal law may, unless in violation of manner, constitute a violation of requirement. The judge must comply with the law. So if you go over the rules of professional conduct, the judge has to go along with that. Okay. Every judge subject to the Code of Judicial Conduct upon being convicted of a crime, except misdemeanor traffic offenses and other traffic ordinance violations, not including the use of alcohol or drugs, shall notify the appropriate authority. Okay, but promoting confidence. 1.2, a judge shall act at all times in a manner that promotes public confidence in the independence, integrity, and impartiality of a judiciary, and shall avoid impropriety and the appearance of impropriety. See, these are, see, that's 1.2. So we're going to go down to the comments, and these comments warn a judge. You see, this is basically telling them how they have to do this. And if they don't do this, then they're in violation of that canon. Okay. Public confidence in the judiciary is eroded by improper conduct and conduct that creates the appearance of impropriety. This principle applies to both professional conduct of a judge, professional and personal conduct of a judge. A judge should expect to be the subject of public scrutiny that may be viewed as burdensome if applied to other citizens, and must accept the restriction imposed by the code. Okay, but you should really print this out and go over it. Ethics, opinions. See, all this down here is telling a judge how he's supposed to apply 1.2. So you can use any of this and all this against them. Okay. Ethics, opinions. avoiding abuse, avoiding abuse of the prestige of judicial office. A judge shall not abuse the prestige of judicial office to advance the personal and economic interests of the judge or others, or allow others to do so. Canon 3, a judge shall perform the duties of judicial impartiality competently and diligently. So why did they let lawyers or your assistants of counsel ask for numerous continuances? It's like, a teacher allowing a student not to come to school without their homework for months, maybe years on end, and find it totally acceptable. Well, you're going to pass even though you didn't bring your homework. No, it doesn't work that way, people. You have to go over this, seriously. Judicial duties must conduct. I'm looking for a certain rule. Partiality and fairness. A judge shall uphold and apply the law. See why I keep mentioning rule of law? Magna Carta. Remember that term, Magna Carta. I'm old school. That's an old school term, Magna Carta. So if you're out there protesting, protest for, Magna Carta. They must comply. Judge shall uphold and apply the law and shall perform all duties of judicial office fairly and impartially. I'm trying to make this as short as possible, running at 36 minutes. But just go over this. Although each judge comes to the bench with a unique background and personal philosophy, a judge must interpret and apply the law without regard to whether the judge approves or disapproves of the law in question. When interpreting the law, a judge sometimes may take good faith errors of fact or law. Errors of this kind do not violate this rule. It is okay. Oh, this is a good one. Rule 2.3, bias, prejudice, and harassment. A judge shall perform the duties of judicial office, including administrative duties, without bias or prejudice. That's part of what I mentioned in my elaboration of rule of the law. See, if you go over this, you'll understand where I robbed some of my wording for rule of the law. That was my interpretation only, okay? But see, it can be yours too. As I said, from my mind to your mind. This is on my mind. My thoughts are your thoughts. These are my thoughts. Let them light the way. Okay, two, judge shall not, in the performance of judicial duties or the words of conduct, manifest bias or prejudice or engage in harassment, including but not limited to biases, prejudice, or harassment based upon race, sex, gender, religion, national origin, ethnicity, disability, age, sexual orientation, marital status, socioeconomic status, meaning because you're poor or rich, which we've been divided, right? Or political affiliation, and shall not permit court staff, court officials, or others subject to the judge's direction and control to do so. That means anybody that works for the judge, under the judge, in the judge's court, they are subject to that. A judge shall require lawyers proceeding before the court to refrain from manifesting bias or prejudice or engaging in harassment based upon attributes including but not limited to race, sex, gender, religion, national origin, meaning where you came from. If you're a citizen, you're a citizen. National origin, ethnicity, disability, age, sexual orientation, marital status, socioeconomic status, meaning whether you're rich or poor, or political affiliation against parties, witnesses, and lawyers or others. The restrictions of paragraph B and C do not preclude a judge or lawyers from making legitimate references to listed factors or similar factors which they are relevant to the issue. Okay, so you're going to want to read this. Like I said, just get you one of them little yellow highlighters, and I say yellow because that way if somebody wants to copy that, use another color to black it out when they scan it. Harassment is referred to paragraph B and C as a verbal, physical conduct that disintegrates or shows hostility or aversion towards a person on basis of such as race, sex, gender, religion, national origin, ethnicity, disability, age, sexual orientation, marital status. Hey, LGBT or community, you hear that? Sexual orientation. People saying they don't have to make a cake for you. Well, the judge is supposed to go along with you because your sexual orientation shouldn't matter. Marital status, socioeconomic status, or political affiliation. Now, a lot of judges do this, and I went on the internet and I seen sexual harassment includes but not listed to sexual advances, requests for sexual favors, and other verbal or physical conduct of sexual nature that is unwelcome. So if you know anybody that works in the court and they've been sexually harassed, maybe they should notice and file with the Judicial Inquiry Board. External influence of a judge, judicial misconduct. A judge shall not be swayed by public clamor or fear of criticism. A judge shall not permit family, social, political, financial, or other interests or relations to influence the judge's judicial conduct or judgment. See, I don't understand how judges can be placed by the political parties based on their political affiliations. They're flooding the court with Republican judges to outweigh the Democratic judges. That's ridiculous. I don't like politics, and that's what's ruining us all. And I mean us all. I mean the people. We the people. A judge shall not convey or permit other or to convey the impression that any person or organization is in a position to influence the judge. Competence, diligence, and cooperation. A judge shall perform judicial administrative duties competently and diligently. A judge shall not cooperate with other. A judge shall cooperate with other judges and court officials in the administration of court business. Okay, there's a lot I want to go over. I'm trying to make this under a 9. Ensuring the right to be heard. A judge shall accord to every person who has a legal interest in the proceeding, meaning you, or that the person's lawyer, the right to be heard according to the law. A judge may encourage parties to a proceeding and their lawyers to settle matter in a dispute, but shall not act in a manner that coerces any party into settlement. Okay, responsibilities to decide. A judge shall hear and decide matters assigned to the judge except when disqualification is required. In one case I had, the judge was related to the plaintiff. And that was my ex-fiance, and so they were related, but nobody told me. And the judge should have recused herself. So you're really going to want to go over this stuff. A judge should hear and decide matters assigned to a judge except when disqualification is required. Otherwise, they're required to recuse themselves. They don't have to say, I don't want to be a judge anymore. You better kick this into another court because I may feel some kind of way about who's in my court. Decorum, demeanor, and communication with jurors. I'm going to go over with special rules for the juror. There's rules for the jurors that they don't tell them. A judge shall require order and decorum in proceedings before the court. A judge shall be patient, dignified, and courteous to litigants. That means you or your assistants of counsel, jurors, witnesses, lawyers, court staff, court officials, and others with whom the judge deals with in an official capacity, and shall require similar conduct of lawyers, court staff, court officials, and others subject to the judge's direction and control. A judge shall not comment or criticize jurors for their verdict other than a court order or opinions in the proceedings. Ex parte communications. A judge shall not initiate, permit, or consider ex parte communications or consider other communications made to the judge outside of the presence of parties or lawyers concerning a pending or impeding matters such as follows. But I'm trying to get judicial statements on pending and impending cases, disqualification, A judge shall disqualify himself or herself in any proceeding in which the judge's impartiality might reasonably be questioned, including but not limited to the following circumstances. Judge has personal bias or prejudice concerning a party's lawyer. Personal knowledge of the fact that is in dispute in the proceedings. The judge knows that the judge, spouse, or domestic partner, or person within the third degree of relation to either of them or the spouse or domestic partner of such person. Okay, a party proceeding with an officer acting as a lawyer in a proceeding. I'm looking for reporting misconduct because the judges are supposed to report the lawyers if they don't follow the rules of professional conduct. Lawyers are supposed to report judges if they violate the code of judicial conduct. Everybody's supposed to report each other if the rules or the codes are broken. The judge who knows that he or she individually or of a fiduciary, meaning the courtroom, or the judge's spouse, domestic partner, parent, child, a member of the judge's family residing in the judge's house has an economic interest in subject matter in controversy or in party of proceedings. Okay. There's a whole lot of stuff you can use against them. Supervisory duties. Judge shall require court staff, court officials, and others subject to the judge's discretion and control to act in a manner consistent with the judge's obligations under this code. Administrative appointments, you'll want to go over that. Disability and impairment, a judge having reasonable belief that the performance of a lawyer or another judge is impaired by drugs or alcohol or by mental, emotional, or physical condition shall take appropriate action, may include confidential referral to a lawyer judicial assistance program, reporting judicial or lawyer misconduct. Okay, that's what I wanted to get to. A judge having knowledge that another judge has committed a violation of this code that rises a substantial question regarding the judge's honesty, trustworthiness, or fitness as a judge and other aspects shall inform the appropriate authority. Okay, so the judge can see this shit on TV or read it in the newspaper and another judge says some lame-brained, crazy statement or makes a ruling in favor of somebody like affluenza. You know, every judge was bound by their duty, according to the rules of professional conduct, to report to the, that's not normal. That is not in the interest of the public. It does not serve the interest of the public. Remember, all this is for the greater good, okay? A judge knowing that a lawyer has committed a violation of the rules of professional conduct that raises a substantial question regarding a lawyer's honesty, trustworthiness, and fitness as a lawyer in other respects shall inform the appropriate authority. And judges don't do that. See, that's why you got to do this. Rule of the law. Magna Carta, y'all. A judge who receives information, including a substantial likelihood that another judge has committed a violation of this code, shall take appropriate action, meaning reporting this to the Judicial Inquiry Board or whatever the name is in your state. A judge who receives information indicating substantial likelihood that the lawyer has committed a violation of rules of professional conduct shall take appropriate action. Okay. Cooperation with disciplinary authorities. Okay. Canon 3, a judge shall conduct a judge's personal and extrajudicial activities to minimize the risk of conflict with the obligations of the judicial court, judicial code office. So there's a lot you should know here, okay? So remember, you want to find it in your state because, listen, I've been going over a couple of them. I'm doing Colorado's right now. And on their sites, they don't, it's not there. This is not there. So you'll actually have to, whatever state you're in, like for instance, Colorado, just Washington, Maine, Michigan, just type in your state and then the code judicial conduct and it'll take you to this, okay? 49 minutes, almost 50, I just want to help you. All right, that's all I want to do is help you. You helping Me helping you is helping me, and we need to help everybody else, okay? Magna Carta, remember, Magna Carta, rule of the law. This is how it's supposed to work. Good night.